of the offer. Now, beyond those first two elements, we then have a requirement of a third element. The third element of an enforceable contract is we must have consideration. Consideration means the exchange of the promises. Each party is going to give up something of value. Maybe the consideration is the contract is going to have consideration in the terms of there's going to be a deposit of $500. That may be the consideration. Courts generally do not look at whether the consideration seems to be fair or seems to be valid. And one of the many places you'll see this reflected is when you have a deed to buy property. Oftentimes that deed says, I'm conveying 500 acres of prime real estate for $10 and other valuable consideration. Well, on its face, $10 for 500 acres of prime real estate would seem to be inadequate consideration. But courts really only look to the existence of consideration and not its adequacy. There may be sometimes that they'll look at that further, but to meet the minimal level of whether or not you have an enforceable contract, you have to have consideration, and it's this exchange. It's what lawyers often call the this for that. I'm giving you this, and you're giving me that. You'll hear lawyers sometimes refer to it in Latin phrases, the quid pro quo. The quid pro quo, the this for that. I'm offering you this, and I'm getting that. And so it's something of value that's being given up, or it's this exchange of promises. The next element of an enforceable contract is that you must have competent parties. Competent parties. And what that really means is you're looking for, back to this idea of the meeting of the minds, the capacity to understand. If you do not have the capacity to understand what's being agreed upon, then you're not competent. And you don't have this meeting of the minds. You don't have this mutual acceptance. So the underlying thing about a competent party is that they have the capacity to understand. That means they have normal mentality. We don't expect somebody to be a genius, and we don't say, well, this was a person of average intelligence, and they really needed to be somebody who was way above average to have comprehended what they were agreeing to. We have many times when you purchase a house, you have a very complicated legal contract. If you're borrowing money, you may have dozens of pages of agreements and disclosures that are involved in that loan. Do you have to be, as we would say, a Philadelphia lawyer, meaning the smartest of the smart, to understand that contract and that mortgage and the promissory note in order for you to be competent? No, we don't require you to be a genius. We just require you to be of normal mentality, and you can enter into agreements that maybe you don't fully understand. In our system we say, well, if you don't understand something and you're going to sign your name to it, then maybe you should be seeking legal counsel to help you understand. Or maybe it's not a legal counsel, maybe it's a real estate agent, maybe it's a mortgage broker, maybe it's a family member who has had more experience with this particular area. But at a minimum, you must have the capacity to understand. So if you do not have normal mentality, if you have been declared by a court to not be competent and not be able to enter into contracts and to be held responsible for having entered into a contract, if in fact there's a court order that says this person may be physically competent, but they're not mentally competent to handle their financial affairs, and therefore we're going to appoint a guardian to look after their financial affairs, or a trustee to manage their property. So if you have a declaration by a court that somebody is not of normal mentality and that they're not competent, then it doesn't matter that all of the other elements exist. It doesn't matter whether they may look to a stranger like a completely normal and competent person. If in fact there was a court order that said they're not mentally competent, then it doesn't matter what they've signed. It doesn't matter. They will not be held to account for this contract because it's lacking a competent party. It's lacking one of those 6 major elements. This raises the question of, you can't be impaired by injury or mental disease. Now, in our culture, we say, well, look, that's not anybody's fault if they're impaired because of an injury or because of mental disease. So the fact that they are impaired by injury or mental disease, we are not going to say that they are competent, and therefore that element is lacking. In the last, 30, 40 years, we've started to say, well, you know what, if somebody is on drugs or if somebody is under the influence of alcohol, those things are really just like injuries or mental diseases. And so if they're on alcohol or they're on drugs, and those drugs or alcohol have impaired their capacity to understand what they're doing, then they're not a competent party. Now, the